Vishnu Madam, for inviting me here for this series of UGC Strike. And yes, as Mr. Joseph has mentioned, the area of intellectual property rights is a growing field. And today, as we see in the current times, over the past few years, we have seen so many changes uh, to the legislations, to the rules, and post the parliamentary committee report, there are so many changes happening in terms of even the implementation. So we are at a time where we need to really look at how this can be utilized well for the national objectives. So in my talk today, I will deal with the aspects of implementation of IP laws from a general perspective. This is a topic which can run over many hours if you really look at each change that has happened and what is the outcome out of it. Now, while taking up some of those aspects today, I'll also uh, discuss with you what are the challenges that we have at hand, considering the changes that have happened and considering the technology changes that we're looking at, the changes in the startup ecosystem, and more importantly, from the perspective of the country now moving into development. So whenever we look at design and development happening at the domestic end, then that is the place where we are really concerned about the aspects of IP. So let me begin with, and then we can. I'll devote some time for a discussion and an interaction towards the end. So I'll just share my PPT, and then we can continue. Yes, are you able to see my slides? Hello?
Yes, ma'am.
Okay, okay. I'll put it in the hourglass mode. Is it okay now? Are you able to see it in the slideshow?
No, ma'am.
Okay, some of you are able to see, it seems like.
Yes, ma'am.
Okay, then we could continue. I have been assigned the topic of implementation of IP laws and what are the recent challenges. I must admit that when you really look at the recent challenges in intellectual property laws, there are so many. I come from a predominant practice in the area of patents. So certainly I'll be dwelling more into that, but I'll also take up each of these IP laws and also we can discuss about what are these which are changes which are which are actually impacting applicants on one end, then the prosecution on the other end, and also the practice from the point of view of how we see court-based pronouncements and how those are being actually considered. So let me begin with the overview. So I deliberately did not put the cross-country context slides, but I'll be discussing more of it. Otherwise, the presentation would go into several slides. So first of all, a peek into the Indian IPR laws, and then we look at what are the amendments to legislation and rules, how do we see the changes in PTO practice, and judicial pronouncements, how they've had effect when it comes to the interpretation of individual intellectual property legislations. Now, from a cross-country context, these become relevant because if you look at some of the areas in intellectual property rights, especially certain areas of intellectual property, where we are talking about the implementation at the digital end, we are looking at new technologies such as AI. Here we look at the need for more global front in terms of filing, and that's where we are impacted by the cross-country context. I'll discuss that towards the end. So all of us are well aware that India is a member country to the TRIPS agreement, and thereby we have amended certain laws, we have brought in new legislations. TRIPS brought in what we call the minimum standards in relation to IP. And therefore, the compliance comes from the point of view of the minimum standards. Now, TRIPS also is a balancing part from the point of view of the developing countries mounting challenge with respect to the IP provisions, thereby bringing in the flexibilities into the TRIPS agreement. So as a member country to the TRIPS, we are compliant with the minimum standards, and certainly to meet our national objectives, we also have the provisions that safeguard the public. We also have provisions that take care of national objectives in our country's legislations. So when we look at the intellectual property legislations in India, the one context that we're looking at from the implementation is the TRIPS and the post-TRIPS scenario. And then more recently, India has also amended many of its laws. Many of them are in the process in terms of some of the rules are not yet notified, but the stakeholder comments are being invited. So we are at a very interesting time from that perspective. India continues to be a very important voice at the international fora when it comes to access to pharmaceuticals, access to knowledge, availability of work of certain nature in terms of the copyrighted works. Not only that, India is also one of the very important members when it comes to the context of reaching in future treaty with respect to TK. And as you may be aware, September this last month, there were a lot of discussions happening at the WIPO, Intergovernmental Committee on Genetic Resources and TK, where the draft treaty on TK is still being discussed. So, and there, the linkage with IP is one is TK being one of the very important forms of IP which India wanted to be recognized along with many other countries. The other is the aspect of the need to include disclosure. So when we look at the different patent regimes across the world, the need to disclose the source of origin on one end, the source of genetic resources is becoming a very important aspect, because that is when we look at the context of monitoring the use of bioresources for intellectual property purposes. Of course, it is at that stage we discuss more on the benefit sharing aspect of it. So this is one aspect. I'll move into the implementation of IP laws, but I thought it is important for us to set the context in which we are discussing all of this. So this is one aspect of it. India also is at the center of a stage where India is also looking at negotiating certain FTAs very carefully and cautiously when it comes to that. Developed countries are looking at bringing in FTA-related aspects to neighboring countries to see how that route can enable the entry to India. So the free trade agreements and intellectual property provisions is one another important aspect. For instance, some of you may be aware India, UAE, CEPA is one. So India has a limited number of them. But if you look at the developed countries, have several FTAs. So from the point of view of implementation of IP, the context of FTA assumes importance because FTAs typically would, again, I'm taking the point of view of, if you look at it from the developed country context, where the TRIPS plus provisions are being insisted on, greater term, non-insistence on compulsory licensing, recognition of know-how and trade secrets, then introduction of patent linkage, introduction of patent term extension, patent term adjustments are only just few of them. Then not only that, enhancement of the nature and scope of subject matter is also becoming an important consideration. So when we look at the aspect of implementation of IP in a country context, we are obviously looking at the influences of each of these and how India is actually keeping its policy in terms of looking at its geopolitical situation on one end and also looking at the national objectives. So with that, let me move into the core discussion. So we are all well aware of these different forms of intellectual property rights. We have those which are in relation to literary and artistic works, then those which are specific with respect to technology, where we talk about patents and designs, and those which are in relation to the use of certain marks or symbols or logos or shapes or patterns or configuration, which distinctively mention the source to us. They provide a linkage with the source of a product or a service. So that is where we look at the area of trademarks. And today we have realized very few registrations, but the area of semiconductor IC layout is going to become one promising area, considering very recently India has taken forward the Semiconductor Mission 2021 to actually invite many companies into the country to look at manufacturing in this sector. Plant variety protection is specifically aimed at plant varieties and the protection of improved varieties on one end, and also the recognition of existing varieties in terms of farmer varieties, extant varieties of common knowledge, extant varieties registered under the Seeds Act. In the case of India, we have the Plant Variety Protection Farmer Rights Act 2001. We'll take up that a little later. And then, of course, the geographical indications, which are those with respect to goods which are specific to a place or a region and have reputation and are based on the skills of the people and the notion, either it is a natural one or manufactured, or it can mean other characteristics could also be recognized. So I'm sure many of you or most of you should be aware of the different forms of IP. Now let me move into the context of where we are looking at the change to the intellectual property laws. India very carefully looked at the amendments to its existing IPR laws post the TRIPS agreement. And remember, the TRIPS agreement mandates that we have a context of non-discrimination when it comes to those who are from the foreign also applying into India, providing the same aspect, same facility in terms of the procedural and the substantive part, no discrimination. We do see the context of IP laws. On one end, we continue to be listed as a country which has a lot of restrictions when it comes to IPR on certain subject matter. In compliance with the TRIPS agreement, India also chose to come up with certain unique legislations. We'll discuss that as we go forward. Now, when we look at the Copyright Act in India, you're well aware of the copyright legislation and the rules. We have the nature and scope of subject matter now also including the digital arts, performer rights, sound recordings, all of these as well. And India also has amended its copyright legislation based on the two WIPO treaties. So we do have the copyright treaty and the phonogram treaty. In tandem with that, India has also amended its. So the amendments that are affected are in relation to that. Then the need to bring in a licensing mechanism in terms of the different licensing opportunities is also included under the copyright legislation. Then the context of looking at access to knowledge has become very important internationally. And in consonance with the international discussions that have been happening with respect to making available the works, copyright works, to physically disabled people, these things are also now into the legislation. Greater protection of authorship is another aspect that we see from the point of view of the copyright legislation. Today, there is a greater assertion when it comes to the context of related rights paradigm in India. Now, earlier to this, we had a notion of related rights, but the expansion of the related rights context has been enhanced based on the amendments that have been effected. Therefore, when we look at the definitional aspects under the Copyright Act, many inclusions have been there with respect to the what means an electronic medium, and the expansion of what an electronic medium can mean with respect to the identification of the copyright. This is one aspect. Often we do hear a lot of cases with respect to the violation of copyright with respect to performances. So to what extent or to what range can we take the context of the right of communication is another aspect. So it now today includes also the performances. When it comes to artistic works, remember, if something is drawn by using a laser onto, let us say, a digital medium, would that constitute an artistic work? So therefore, those which are the arts which are seen by the digital medium, recognition of that in terms of that particular fixing in that medium is also become necessary. And the context of sound recording has also become quite relevant. I can tell you an example of how, in the current times, the entertainment industry or the industry which is dealing with, let us say, um, recordings and things like that, is in a better situation compared to the earlier times, because in the earlier times we did not have so much of digital implementation. Not only that, the recognition of the rights in terms of the individual aspects of a particular performance was not so clear. So therefore, today we have a greater assertion of copyright compared to the earlier times. I can tell you of a very popular lyricist who happens to be a relative, who lost a lot of the copyright, or rather I would say could not assert copyright, because it was at a time when the notion of the copyright and its translations into all those different aspects of it, or its fixation into those different aspects, were never considered as part of the entire mechanism. So I do remember the family member quite aggrieved. In fact, the songs continue to be very, very popular even now. But now these have gone into different modes, into the digital recording, into other aspects of it. So unfortunately, they are not able to claim back all of that, though they have actually, approached the IPRS. So there are concerns. This is one part of it. Now, when it comes to, let us say, the entertainment industry, we also need to look at the context of how contributions can come in different ways in terms of quality and in terms of the quantity. And finally, you see, a film coming up, or let us say a video recording coming up. Today we have internet-based short films. So how do we see the copyright aspect of it taken care of in terms of the protection of copyrighted works becomes very relevant. We have both sides of the coin in that sense, because I remember recently there was an issue of someone utilizing a small component of satellite films into an educational, course. And the question of whether or not that would constitute a copyright infringement came into picture, because someone who is sitting out there in the UK suddenly noticed that this course is having a less than 2-minute video of it. So quickly they contacted and said that, look, we have been charged with this, and so how do we go about with this? Of course, we do have fair dealing under the copyright legislation. So to what extent it means an infringement is all dependent on to what is there a substantial use of it. And certainly the substantial use of it, how much of it is reading into the commercial intent or not, becomes relevant. So those are the things that we continue to see. Then a lot of the content today is on the digital medium, and therefore the changes to the law in terms of bringing in the aspects of looking at the performance rights paradigm, looking at the cinematographic works, has necessarily required a need for technological protection measures introduction. Thereby, we also have the aspect of digital rights management. Now, then comes the aspect of coming up with copyright guidelines. In other countries, there are specific guidelines with respect to copyright, which industry typically follow. And to some extent, this is part of what we call the copyright audit. So copyright auditing is something which is, you know, quite common there, but we need to now see more and more of that copyright auditing happening, because then attribution with respect to each aspect of copyright becomes relevant. Of course, the fair use clauses are also extended to these works as well when we look at the legislation. Now, in terms of the copyright board, there have been a lot of simplification. Then also, today we do not have the capacity to search for works seamlessly. So therefore, the changes to the rules also insist on the need for introduction of search, including transparency procedures, giving an annual reporting in terms of the what are the works that are being considered, how are the meetings being held, and what kind of mechanism in terms of the transfer of rights are being looked at in terms of the different aspects of licensing. And today, because of the digital medium, copyright register is also going to be in the electronic form. So that makes it easier for search. Now, I do remember at a time when we filed for copyright, we typically used to wait for some time and just, then get thing from the copyright registry from Delhi that, okay, this is for this reason, we need additional details. So we need a little bit of simplification when it comes to the registration procedure. We still have the requirement of CD inclusion, which makes it very difficult for common applicants. We are not talking about institutional or copyright, as you know, is a very individual thing in terms of other. Copyright exists by way of creation. But why would one go for a copyright registration? Because today in the digital form, you see a violation of copyright has become much easier. So if someone just copies a cover page, and my cover page of a book is so unique, or let's say I've come up with a recipe. This had happened actually. In case of a recipe, this was something where, it was about a vessel in which there are two fish in the opposite direction. It's possibly Hilsa. There was a case on the which was being looked at in terms of whether or not that constituted a copyright infringement. So with digital works, we see the greater need for monitoring of copyright. So that is something which we need to realize more. So the changes to the rules have happened, which is good in terms of recognizing these aspects and firming up the entire process of procedural aspects as well as the copyright society part. But we do still have the challenges with respect to the implementation. And as you are much aware, the growing internet usage is bringing us closer to the aspect of accessing digital works. Now, the question of how much of copyright is available in respect of a digital medium in terms of a web page? What about the access from the cloud? How much of that would be, the need for copyright permissions are required? What kind of mechanism is there? These things are all more individual in nature based on the publisher or the one who is actually putting in the content. So tracking the violations on the internet has become much more difficult. So the context of internet piracy, I'm sure you would agree with me, has become much more pervasive, and detecting copyright infringement has become difficult. Though if you look at YouTube and all of those, there are takedown notices, all of it. But you do not know where all these things can actually go to. So that calls for a need for a stronger protection of copyright. And today we also know that there is a linking aspect of it. When you click on something, it actually goes to another website. So would it mean that there is a kind of a facility created and an indirect infringement? So linking is also creating those kind of scenarios which need to be addressed. There is a lot of work that is being shared in the social media. um, People are writing blogs, travel logs, and whatever logs those are called. So, uh, yes, original works on the internet. You don't know who is using what part of it is and combining it with what else. So you also know of the cases in films where they've used a particular dance form or a folk song, all of those. But some things may not be yet, possible to really trace. So uh, one should be very careful when it comes to putting in material on the web. And today we say you can put in copyright and the year and the name, but what that really means is just putting in that. But how constructive is such a notice is a question, because enforcement is a problem. So greater governance is required when it comes to social media platforms, whatever are the platforms, whether they're information based or they're technical based. These are necessary to look at. Um, Today, we see an interface of copyright sometimes with even the context of patents, because typically when we talk to inventors, and inventors are working in the digital medium, the question of putting in data or the correlations of data on a common platform uh, is again information which is expressed, right? So all that correlations that are coming up in relation to data, not the data itself, form an important part of the information. So if you, let us say you're putting it on a server, and you don't know who is accessing, how they are actually uh, uh, incorporating that into some other material to come up with the next copyright. So this kind of thing is very hard to detect, frankly. Um, I had a very strange scenario, examining a PhD thesis where the work is completely on folk music, on and how there is a need to recognize, or rather, the work basically dealt with how intellectual property paradigm can be applied to folk music. And so therefore the a significant part of the work was an entire field survey of uh, this particular folk music. um, Now, a lot of the information that is there is actually uh, in the form of that thesis. So my big worry was not about the access of that thesis once it is published, but about how people could actually violate, not attribute, uh, and easily take away that information. So those considerations become very relevant. So I insisted that very unlikely as an examiner one would write. I insisted that the work be published in an Indian Journal of Traditional Knowledge, because that is recognized under the PCT minimum documentation. So if someone were to come up with a recording of this and all of those, because they had that information, in form of different annexures. So that would mean that some way we are really looking at the protection of IP. So there are some of these concerns. Of course, we discuss a lot about liability of intermediaries in terms of the internet service providers. Uh, Again, uh, internet is such a space that you do want regulation, but you do not want it more than adequate. And at this point of time, it has become such a medium that it's quite unregulated. So From the copyright context, if one looks at works, uh, it is all about actually how well you monitor your copyright, um, which is something in many jurisdictions people are actually bringing in several measures, and that's where jurisdiction considerations are quite different dealing with these aspects. uh, Reading the scope of fair dealing is something uh, which is important to look at, especially when we are looking at online works, we are looking at availability. Today, the access to knowledge paradigm has grown like anything. There are several pronouncements, as you are also aware of, where courts have really looked at the public policy considerations and have said that the assertion of copyright actually is completely against the tenets of promoting dissemination of knowledge. So therefore, this is something that is again a big challenge when it comes to the implementation of the protection in under copyright. There are several aspects of it institutionally when you handle. Of course, I didn't put it here because that's not typically a challenge with the Copyright Act implementation, but a wider issue is actually about originality. The How do you really determine originality in a context of today's rapidly world, in this world in which things are so highly mobile and so rapid is the transformation of information. There comes the aspect of looking at how much of it is an adaptation, and today, if it is an AI which is coming up with information, then how do we really look at the uh, context of copyright? And you know that OpenAI has been sued by many of the because the question of taking in a lot of different copyrighted works and then developing the algorithm in order to return back, you know. So that has also become a very important paradigm. So uh, we need to wait and watch the OpenAI, the litigation in the US, and what comes out of that. There are, of course, defenses that they are not using it as such. So therefore, but then what amounts to a copyright infringement will be very interesting when it comes out from there. And you also are well aware of the Delhi High Court judgment where the case of an AI, whether an AI can be used, in terms of looking at returning back information on whether AI can tell us whether it is original or not. So that cannot be taken as part of the court proceedings, is what the Delhi High Court has clearly ruled. So we are in a very interesting scenario where what is original, is one issue. The other issue is actually the moral rights paradigm. I'm very sure some of you are very interested in the area of moral rights. What would mean a mutilation of a work is very difficult to really envisage in the current day's context. So, to what extent moral rights should be insisted on, and how do you again monitor this part of it, is again a huge challenge. And so that is something we're looking at again as a big challenge in the with respect to the different notions with respect to what is moral right, the scope of it. So something may be considered highly mutilated, but others may think it is not so, and it doesn't really impact. So those things are again, some of those things are important. The other challenge is actually in the licensing mechanism. We do have copyright societies in India, but again, there are different licensing mechanisms. But from the point of view of uh, a general mechanism for licensing, I think we need to have guidelines being developed. For instance, we do have guidelines in other laws with respect to benefit sharing, with respect to royalties. Uh, yes, there is a general mechanism under the Copyright Act, but I think we need to really look at, based on different works, how this can be done. This will be very helpful because then that will really bring recognition to the works, with respect to copyright. The last part is the copyright audit process. The copyright audit process is something not so very widely implemented in India. You see, typically, we do a lot of audit when it comes to intellectual property audit. But how much of that intellectual property audit takes care of copyright audit is a question to ask. Well, industry may be doing something, but we are not aware of how much of that copyright audit really happens. In terms of valuation, in terms of looking at the licensing mechanism, all those aspects, which includes also to what extent you're combining a work with another work. That there comes the typical audit as well. So, copyright audit process, we still do not have any industry specific copyright audit process, which are of course available in the public domain. So now this is not only relevant for industry, I believe that the copyright audit process is very, very critical for institutions. Maybe I'm ignorant, but at least to the best of my knowledge, I do not know of any institution in India which has a specific copyright audit policy. So an intellectual property policy is there in many institutions, in most institutions, but how much of that takes into consideration a copyright audit? Because see, today, if you look at institutions, their rankings and the work, a significant part of the academics is into publishing, is into publications, book writings, academic works of different nature. Having a good copyright audit process helps in the compliance with respect to copyright. And so therefore, I think this is something which will be very useful. In fact, I don't know why is it that we don't have even copyright compliance workshops in institutions. I think that's very important to have that. We have a lot of workshops in patents, we have a lot of workshops in designs, in generally intellectual property workshops also. But when it comes to copyright compliance, this is something that we need to really have, because today students come up with short videos. They are posting it on the net. You don't know who is taking it from there. Now, I remember a student came up with a very good digital art. How to go about with copyright registration? What is a safe introduction onto the internet? These are things which come as part of the copyright audit. So I thought this is something which is important. So I bring this to your attention as well. So these are some of the challenges, obviously, with respect to the Copyright Act in India. We next come to the aspect of patent law. As you're aware, post-TRIPS, significant amendments have been effected by Jan 1, 2005. Rules have been amended at various time points. We, at this point of time, also have the 2023 draft rule, which is where they're inviting comments on the rules itself. So from the point of view of the patent legislation, we are looking at, well, this is just a tabulated thing of the 1999, 2002, and 2005, which are relevant from the point of view of looking at the compliance with respect to TRIPS, and also including certain chapters with respect to international filing. For example, PCT filing 135 onwards, we have section 135. Then we also have the changes that are happening to the patent office more from the point of view of easing up on the rules, particularly with respect to India going strong on the startup process. So inclusion of startups, small entities has become relevant, not just for the patent legislation, it's also true for the Trademark Act as well. So if one looks at the the 2021 rules, the need for improving an institutional innovation ecosystem is where we recognize under because of the changes to the rules by including educational institution. So if you are an educational institution, then again there is fee reductions are there, and then of course small entities, startups. So obviously the schedule with respect to fee has also changed, and then separate forms are also introduced as part of the changes. This is one aspect. Then of course, if you look at the draft rules 2023, this is going to really make a big change with respect to patent prosecution. Just briefly, I would like to mention some of them and how that would obviously, the implementation of that would affect the applicant or otherwise. So one is the Section 8 undertaking. As you're aware, Section 8, Subsection 1, Subsection 2. Subsection 1 is a critical requirement in terms of any foreign filing that requires a submission of Form 3 at the patent office in order to indicate what are those applications that are being filed, which jurisdictions, and what is the status of those applications. The requirement was within 6 months earlier. Now today the suggestion that is coming up as part of the rule change is that it can be done even at the FER stage, that is 2 months from the issuance of within 2 months from that. So that means there is a progressive aspect of the postponing the compliance under Section 8. On the other end, because we have the digital platform, the controller will be able to also access information already of those applications which are filed outside India. So therefore, this is something which is eased out. I'm happy to note this because this was the suggestion that we made as a part of our World Patent Information paper, that this was a paper that we published on a duty to disclose. So this comes under that compliance. So the duty to disclose comes under Section 8, Subsection 1. And if you remember the cases of Chemtura versus Chemcast Corporation, this became like a very substantive provision by way of which the patent could be revoked. There are several set of cases even beyond that. So this has become a very rigid compliance, and this has been eased up. So from the applicant point of view, it is very good. It has eased out that part of it. And this is one part. And condonation of delay also can happen if you're filing a form for requesting the condonation of delay. This is one part of it. Hitherto, if you remember, divisional application is at the call of the patent office. That is, if there are cognate inventions in a patent application, then typically the patent office would tell you to elect. So if let's say there are 2 or 3 inventions, as you know, the requirement of one application, one invention is under the law. Thereby, the patent office would typically invoke a requirement under Section 16 to divide out the application. So this was typically at the call of the patent office, never at the call of the applicant. Now, LG controller versus LG Electronics versus controller, this clarified to us very clearly that this or that is there in this section is at the behest of the call is at the patent office's end and not at the applicant's end. But today we see a rule change wherein this has been indicated that if the applicant so desires, one can file a divisional. So we do not know how, certainly it's applicant friendly, but would it also mean that I can escape filing of so many different applications by putting in too many inventions into one and ask for a series of divisionals at the patent office? Possible. So this is one danger, if you look at it that way. At this point of time, we do not know if it can become an abusive process, but certainly applicant would like to favorably use it by putting a bunch of inventions into one application and then telling the patent office that this is a rule that you have provided to me, and so therefore allow me to divide. And one application I can divide out many. So this is one part which we need to really look at. 24B rule change is with respect to examination. Request for examination typically has been, is, not has, is at 48 months from date of filing. Now, if the rules are notified, then it will bring into a lesser time of 31 months. And I believe that possibly this has been brought in keeping in mind PCT entry, which is 31 month for India. So to bring it in tandem with that. So this could be actually favorable in some sense. The other thing is question of compliance. So we have some additional compliance now coming up, which can be a challenge because materially it can affect novelty with respect to applications. And this is the one with respect to 29, Rule 29. So there is a grace period that one can invoke with respect to the anticipation clauses. So it shall not be considered anticipated even if you have disclosed that at a conference, because 1 year time period is available to you. But now there is a separate form that has come up. That means if you want to invoke the grace period, you have to fill up this form and the particulars of that. So this shall be taken as the part of the submission. So good, but then the question of compliance comes in terms of how would it be examined? What are the particulars that need to be really looked at very carefully is a consideration, because then otherwise it will affect novelty. 55, the Rule 55 change with respect to that is with respect to pre-grant, the costs are risen. That's one big problem, because earlier we did not have the requirement of fee payment. Another thing is that in the case of the current procedure, we have the controller generally looks at the representation and then the proceedings start. But here, if the rule change takes effect, the 2023 rule change, then it will also mean that the controller needs to also decide on the maintainability. That is something which is again where there could be considerations, and to what extent. So how would controller really look at that? That comes to the question. Normally, by the response time is 3 months, it has been cut down to 2 months in terms of the response back by the patentee. So this is one aspect which has been, and in any case, the time period for the entire hearing has also been cut down to 3 months. So quick disposal is what is being looked at. In terms of the maintenance of the patent, another rule change has come in, which is favorable in terms of bringing in, if it's a block period, then you can have 10% reduction in the fee. This can be beneficial for some, especially for small industries. The cost is too high. As you know, the more the time into the patent grant maintenance, the more is the fee, maintenance fee, the annuity fee that we pay. So this can be advantageous for small industries in India, and especially startups, which already are struggling for their, in terms of their funds. One reason for concern can be the working of patent, because here, instead of making it every year, currently you need to file for the working under Form 27. Now, if the rule change takes effect, then it will be every 3 years once. So typically, if you know, most people look at Form 27 details to really look at their future to mount a compulsory licensing challenge, things like that. So this would really impact, and to what extent the working of a patent can happen in India, because as you know, working of patent is governed under 83. And that is a very important public interest perspective that we see, and generally under 83. So to what extent we'll be really able to safeguard the public interest notion is something which is going to be seen in future. The time extension things are typically under Rule 138, and these have been also relaxed. So um, that will obviously be useful for the applicants. There are a lot of fee changes that have happened, and so this is generally the view into it. So if you really look at of course, we also have in terms of implementation of IPR laws, we are looking at from the specialized divisions under the high courts. We have the IP division in Delhi as well as in Chennai, and there are more going to come up at other places. So this has also brought in a faster disposition with respect to IP cases, and we do see a lot of judgments coming out from these. Well, these are just the thing with respect to the Madras High Court as well. So if you look at it from the point of view of the country as we are placed now, we see a very interesting time where there are a lot of changes happening at the PTO. So when it comes to patents, we are looking at PTO prosecution is one part of it at the patent office, and then post patent office we are looking at some which is post grant proceedings at the end of the controller, and then of course we are looking at the courts. So we do see a very interesting growth in the patent area, just typically quite not so much except for the PTO part of it. So we need to really see how this goes forward. So what are the challenges that we see in terms of Patent Act implementation is that Form 27 is a critical part for working of invention, and so a delaying of the filing of Form 27 may be potentially disadvantageous to public policy is the contention that I have. Now, pre-grant proceedings, which are actually, again, if you read the context of how earliest you can actually look at opposing a patent, this is a very powerful proceeding that we have, pre-grant 25 subsection 1. Now, somewhere this is going to take a hit because of the too much of a procedural thing has been laid out now in terms of filing of a representation. Now, that is one thing. Second thing, there are costs also. So would it really deter the filing of pre-grant oppositions? And typically, we have seen a lot of pre-grant oppositions in the case of pharma, which balances the need for opening out the patents. So how do we, this is going to be possibly also a difficult area for the country if we are looking at the value of these proceedings in the current context to the change of it. Compliance would be affected when it comes to rule changes because 138, there was still a scope of 138 was not really beyond. So, but now 138 has become a little bit more flexible. So time extensions, how they would really affect is something that we need to see. We were not so very form-specific jurisdiction compared to the US, which is too much of form-specific and format-specific. But now with the new forms that have come in, there will be a greater compliance. And yes, it would definitely somewhere be difficult for at least certain applicants. And I'm much concerned about how the startup process would be affected. The other challenge that we continue to face, it is not just because of the changes to rules, but the inherent difficulty in the twin application of the Patent Act and the Biological Diversity Act. As you know, Section 6 of the Biological Diversity Act mandates that no person, Indian or non-Indian, can move with any IPR, including a patent application, unless you take the no objection from the NBA. And that is for a bioresource from India. Given this, the patent examiner would typically put on hold the application, even if the examiner has examined the application. The putting it in order of grant that is the sealing of the patent, would be withheld if a NOC is not obtained. Typically, in most of the examination process, it is all about what happened. You have not presented the NBA NOC. This has become very arduous for applicants because let's say I'm using an enzyme which is a purchased enzyme. I purchased that enzyme from, let us say, a big pharmaceutical, a company which manufactures enzymes or certain so there is it has become a very arduous requirement where we have to give the catalog, and this is true. We are having to give the catalog. This is the number of that chemical. This is purchased from Sigma, and this is not something which we have isolated from a particular organism. So this is one part of it. The other thing is, if suppose let us say I have taken it from a local market, then compliance is too much for me to say that, okay, please give me the origin of the resource, which community you have accessed it from. So this is still a lot of difficulty for those who are applicants who are working in the technology. On a little ancillary end, a lot of examiners have been inducted, but there is also this everyone is watching India because India is now moving with the rule changes, PTO practices, PTO administrative changes are also happening. There are a lot of MOUs with the European Union, with the Japanese patent office as well. In the midst of all of this, and India, as you know, is also an ISA since 2013 October. In the midst of all of it, and with the increased capacity now, one thing that will be watched is how is the capacity building being done with respect to the implementation of the provisions of the Patent Act for the procedural aspects of patents, especially the examination part of it and the hearing. So that means it brings to us the context of the quality of examination and the disposal of applications. And as you know, there have been cases from the Delhi High Court where the court has also given the ruling that many of them are not reasoned orders, reasoned ones from the patent office. So the FER's changes to FER practice is also something that is being looked at. One area of difficulty is still the CRI guidelines. We do also face it institutionally, and it typically deters many people to file for patents in India. And we typically have to tell applicants that please cut down on the graphs, don't show too much of the mathematical formulas, algorithms and all of it, because it reads on the mind of the examiner that all of this is mathematical calculation, it is abstract. So we still have a lot of difficulty in the application of CRI guidelines, let alone in many other jurisdictions. There are AI guidelines also announced, but we yet need to see that happening in the case of the country. Obviously, one question which is not just of academic interest, but that affects also public, is to what extent many of these are actually bringing in a balance of the grant vis-a-vis the availability of public interest with respect to patents. So you have seen the pandemic time, and you have seen how India has faced a challenge with respect to COVID-19. We do have provisions under the Patent Act, but we do also have a clear backlash from companies which are actually coming up with their technologies which are covered by patents. So if you look at the Delhi High Court case with Justice Ravindra Bhatt dealt with, very clearly the government representative said that, look, we are all for invoking the governmental clauses under the Patent Act 92 and whatsoever, but the difficulty that we would face is a backlash in terms of withdrawal of medicines and healthcare from the Indian market. So these challenges we continue to face, but I think as we go forward, yes, a delicate balance of the private reward of patent rights need to be clearly balanced with public policy. And this is a careful path that India needs to tread, because patent rights, as a country which is now moving into the innovation ecosystem, we need to carefully also watch this particular area. Okay, I think I'm taking too much of time, seems like, but I'll quickly move into the aspect of the trademark law and how do we see the changes happening in this. And uh, uh, we do have the good uh, presence of litigation, particularly more so in the trademarks area. We do see a lot of changes happening in terms of multi-class registrations on one end, changes to the process of notice of oppositions, um, and even the introduction of a specific chapter into the Trademarks Act to take into consideration the inclusion of the Madrid Protocol, which provides an easy option of going, or not easy option, but a quicker option of going internationally for filing of trademarks. So, with all of that, how do we see the inclusion in terms of new things? Startup and small enterprise are the new categories we have. Well, the fees is higher. This is a problem in terms of a startup. But if you are doing an e-filing, 10% of it is it comes down. So that way, earlier there were too many forms that we need to look at, but now we have application. There's just the 8 forms that are there. The e-filing process is much more easier. One consideration is the new thing, that is that the well-known trademark category applicants can apply specifically to get the well-known mark listed. So that is something. And separate provisions for sound mark, prior user support documents filing, expediting of the registration process, quick disposition in terms of hearing through audiovisual means, and reduction in the time of the renewal for the expiration of registration was, as opposed to now, you see that even it is available not even 1 year prior to the expiration. So that sort of thing is what is the change we see. Challenges to trademark implementation: multi-class registration continues to be a little difficult when you file with, in case of certain applicants. Online trademark infringement. In fact, I have a student working in the food sector and dealing with the aspect of online trademark infringement, because here we are concerned about not just the trademark part, but we are trying to explore the aspect of reputation, goodwill associated with trademark and food sector. How do you see, and what are the compliance things coming up because of trademark infringement on the online? This is something that is not just for the food sector, it's relevant even for even other products. And with so many things being bought online, this is a big challenge. Determining use and non-use with respect to trademarks is again going to be very challenging, because what are the justifications for non-use will become very important, considering that implementation of trademarks is no longer just only in the physical mode. So this is one contention that I have. If the trademark registry will continue to list a lot of well-known marks, would that create a presumption of an increase in the assertion of infringement, in future by marks which are using, this, but on other products? Non-traditional trademark area continues to still be a little bit challenging, because for Indian industry, which is getting into, let us say, the luxury goods segment or the perfume segment or the herbal segment, we need to really see how this comes up. One aspect which I have raised recently with the small group of IP people is the search for trademarks needs to be improved. Because that potentially, see, for instance, a search for patents is much more easy at the iPads platform that we have. But in the search for trademark, we don't have many options, or rather the interface is still very minimal. So if it can be improved, then people who are searching for marks can be more sure on the registration, the possibility of potential clash with a similar mark or an identical mark. And many times for due diligence procedures also, we need to really understand what are the associated marks. these things are relevant again. So that is something I listed as, again, these are some of the challenges that I thought of listing. Quickly, I'll move into the GI legislation. India has benefited. If there is any other legislation in India has benefited a lot from the domestic end, I can say it is the GI Act. Um, the As you know, GIs, natural GIs, manufactured GIs are recognized. Even processed food categories, GIs are also recognized in India. GI rule changes have happened, particularly with respect to authorized user registration forms coming up, and the particularly the slashing of the uh, registration fee to just to rupees 10. So that's a significant thing. But despite that, we have not realized as many authorized user registrations. We really need to see what happens on that end. One of the biggest challenges, and we also work in the area of GI, and we work on processed food. And when we did a post GI study in the country, what is it that we realize? By looking at GI is another IP which requires a lot of technical documentation, just like patents. The statement of case requires not only the territory map but the proof of origin. Many other countries have really done away with the proof of origin because if you make that mandatory, then the question of registration of a GI is at stake, because often in case of the GI registry, they insist on the proof of the historical record and all of that. But in many cases, one may not be able to exactly track it to a single point. So non-fulfillment because of just some of these, yet though there is so much of documentation, many GI fail to get registered. And people who are authorized users get actually, what do you call that? They feel very disheartened, because we have interviewed a few people where the GI was abandoned. So they say that, look, we don't want to go back again because it's such an arduous process. Already we had done so much of documentation, but just because we did not have one particular category explained, it all fell apart. This is something that possibly we need to think about. There's a lot of counterfeit when it comes to the GI area. How much are we really bringing in GI monitoring? To what extent at the grassroots level in the enforcement machinery, there is the amount of GI awareness. That is something which we really need to look at. GI quality schemes is a big challenge, because many products are not being easily accepted in other countries. Or rather, the cross recognition of GI India is having difficulty, because most other countries come up with a quality certification. And in India, very few products only still have quality certification for GI. So, and typically that is what they ask, okay, yes, yeah, we like this. This is a good process to sweet category, but does it have a certification? So other than the FSSAI certification, we don't have any other special certification names. For instance, now BIS is already certifying GI, which is good. So that also will be helpful. So this is one challenge which we still have. Authorized user registration is still not adequate. So there's much we need to do here at this case. And in any case, the GI is again bioresource based. So how, and unfortunately, the GI Act is all only about registration. There is no post-GI role carved out at all under the GI Act. This is one thing. Interestingly, Trademark Act takes into consideration goods and services, but GI Act doesn't take into consideration service. Now, when I use the word service, it is all actually about the processing activities associated with GI don't have any particular recognition. It's a good which is being recognized, but the good is coming out because of a particular way in which it is being manufactured. And not only that, there are so many other ancillary activities with respect to a GI. Somehow we do not have recognition for that. So this is something we need to look at. Cross-linking of these legislations will be very useful, so that at least so there's so many natural GI. But what is happening on the conservation of GI? GI Act doesn't take into consideration conservation. It's not in the mandate. But in the mandate of the Plant Variety Protection Farmer Rights Act 2001, the preamble itself says for effective conservation. The objective of the legislation takes care of the conservation mandate. So is it possible that the Plant Variety Protection Farmer Rights Authority conserve all the natural GI? Yes, but then we need cross-linking, or we need the administrative linking of both of these legislations. In any case, the Biological Diversity Act 2002 also is another overlapping legislation which is important. There are meetings of the Plant Variety Protection Farmer Rights Authority and Biological and the NBA, which they do have joint meetings, but somewhere linking up of these legislations will also be very helpful. I'll quickly move into the Designs Act in India. There have been changes to the design rules as well. Particularly, I just put in some of them only. Adopting the Locarno classification is one. Again, just in the case of introduction of startups into the patent legislation, trademark legislation, that's also happened for the Designs Act. Revised fees, forms have also been changed. Now, I didn't put in the challenges with respect to design legislation, but typically what we find with respect to design legislation is not many, though actually typically an examiner will examine more designs compared to patents in a month. Still, if you look at the design industry, designs part of it, we don't see much of a presence of the small scale industry. So there is some challenge which we do not know. Maybe it's more of the cost part of it which we need to look at. This is something this is one part of the design challenge that we see in the country. The other thing we see is actually the licensing aspect of design. So we don't see that much of licensing in some of the segments where there's a greater propensity. So that is something. I don't deal much with the design law. So, I mean, these are the two things that I had to actually could perceive. I'll move quickly into the plant variety protection legislation. Here, this is a very important legislation, and India has considered the breeder rights and the farmer rights on the same platform equally, and therefore the name of the legislation is quite just in that sense. There are several varieties that are protected under this law. We have improved varieties which are coming from plant breeders, improved varieties coming from the process of genetic engineering. Then we also have farmer varieties being recognized, extant varieties being recognized as well under the law. The genetically engineered varieties, mutant varieties are all the ones which are typically called the essentially derived varieties. We have registration for that as well. So there is a clear procedure under the law for the registration of varieties. We have realized a lot of farmer variety registrations in the country. There are some states which are really very high in the number of registrations. There are also registrations with respect to each of the other category. But one predominant problem that we face with respect to, or rather it's a challenge, is that to what extent the breeders, whether you call them breeders in the typical, institutional breeders or, hybrid seed companies on one end, and those companies which are agrobiotech giants, to what extent are they considering the benefit sharing with respect to initial varieties? So most often the varieties that you take to cross to create a hybrid are initial varieties, and these initial varieties are typically farmer varieties. There is a benefit sharing provision under the plant variety protection legislation, but to what extent that has been really used to consider the benefit sharing mechanism for initial varieties is a big question. Now, just yesterday we were discussing about whether we should register the one particular variety that has been brought to our attention. Should we register that as an extant variety, or should we register that as a farmer variety? This is where we have difficulties, because fees are typically pretty high in certain categories for plant variety protection to secure a plant variety protection right. Not only that, this is one legislation where you have testing or a examination of a variety, and that examination is called distinctness, uniformity, stability testing, or the DUS testing. The DUS fees are extremely high. Not only that, it is time taking. So can we do something about DUS testing? In terms of, see, in every other legislation, you have decrease in the examination, there's expedited examination fee, there's, in certain cases, there's discounted. Can we have something similar when it comes to this legislation? It's desirable. I can tell you from our experience of registering a farmer variety, everything went well, but now we need to really look at that some other institution has to certify that this is the plant, and that's a very a plant which is quite common in this region, but the farmer is using that for a medicinal variety. So to register it from the farmer's end, we have helped them fill up the application, and it's been submitted. But when it came back, all the details have been accepted, but they said you need to now go and take certification from a nearby institution, and that yes, this is the plant. So I have to now look for a botany department person, or again that should be an institution which is recognized as part of this thing. So these are some challenges that we face. So even if it's a farmer variety, no fee, it's still pending. So these things are there in terms of, then how many of the farmers who have received certificates are able to really enforce in terms of claiming benefit sharing? This is a question, because under our law 39 onwards, we have a lot of provisions with respect to farmer variety. Yes, there are clear challenges with respect to registration, because it is a long process when it comes to the submission of data, and expert identification is one challenge that institutions face, because especially for certification, this is very relevant. It is also necessary, I believe, going forward, if we can have designated institutions under the law. For instance, under the Biological Diversity Act, the notification under the law, there are separate designated institutions which actually help in the conservation objectives that the NBA needs to take forward, or the State Biodiversity Board needs to take forward. Now, if you look at the Plant Variety Protection Farmer Rights Act, also has an objective more towards the plant biodiversity. So if there are designated institutions, that will really help in the implementation or the enabling aspect of this legislation. So this is something which will be very helpful. Again, one suggestion is again to really look at the cross-linking of several of these legislations for the mutual benefit. And ultimately, people, many of these are also community-centric. For instance, the Biological Diversity Act recognizes local communities. Plant Variety Protection Act also recognizes local communities. GI essentially is, most of it is community-specific. So that can also be a very useful thing. Semiconductor integrated circuit layout design, very few registrations we've had. We need to really look at a mechanism of incentivizing more registration. And I think here we really do not have much capacity. Capacity building process is necessary to identify what aspect of that circuit layout is registrable and what is not. So again, we do not have a lot of workshops in this area, and we need to really get ready for it, because India is now going to be a destination for, it is already, they're already opened up a lot of these. There's one in Karnataka and many other places they're opening it up. On protecting know-how and design aspects, it's very critical. So what kind of due diligence procedures are required? So one big challenge that industry faces is protecting the pre-IP in this particular area. From an institutional end also, we do find a lot of people coming up with these. We also look at how this can also be a separate mechanism. So then also including technical measures of protection has become necessary. So what kind of guidelines are there, which we need to really look at to help industry to prevent the chip piracy is also necessary. These are again some of the ones that I've listed. Well, I just wanted to close the talk with this aspect that at this point of time, if you're looking at any manufacturing industry, the implementation of IP becomes very critical from the point of view of if it's a technology-rich or an enterprise or even an institution, we are typically looking at patents and designs, and anything which is pre-IP is a trade secret. So prior to filing of a patent, prior to filing of a design, not to say that other IP are not relevant, uh, but at least if you look at it from how India is now pitching itself to be a big manufacturing destination. And remember, many sectors we have opened up for manufacturing, which were never the sectors. For instance, defense we have opened up for manufacturing. We have a pitch of Atmanirbhar Bharat. That is, in every sector we want indigenization, that is growth of indigenous technologies. So we have a big challenge going forward, and taking the safeguards under the law is not only important, but also hastening the application process, taking the advantage of the changes to the rules as well as the legislation can be quite good. So here we need hand holding, actually, frankly. There are startups, there is ecosystem available for encouraging startups, but I think institutions also need to take it on themselves to be a guide to even the startups, and not just run the academics and research, but also help enterprise and especially help the startups. And the creation of the intellectual property facilitation centers are basically to look at these things, because startups will need that advice, because they would obviously face a lot of challenge with respect to each of these legislations. So I would wind up with that, just to keep this slide for you, that where is it all going to really impact is, yes, the best opportunity that we have is that we have India as a design destination for even designing. So capturing the best of the IP can happen, taking advantage of the current IP ecosystem. So that's about it. And if you have any questions, I'll be happy to take. Thank you.
Thank you, ma'am. There are a couple of questions in the chat box.
Okay, let me just come out of this presentation and then we take this. Okay. Okay, yes. Yeah, thank you for your patience. And yeah, just 1 second. Okay. India has a variety of cultures and traditions, but we do not have a special law to address issues of traditional knowledge. A group of people or community want to protect artistic knowledge. Okay. Is it possible? If possible, is there any specific provision to safeguard TK under copyright law? See, under copyright law, we don't have any specific provision for TK. That much I can tell you. Unlike Bangladesh, they protect TCEs. There are many other legislations in other countries where they protect TCs. But at this point of time, if you say copyright, you can protect it under any of those artistic expressions or any. It's more about that, but not otherwise. But yes, if you really want protection of it, you also ensure that this is included under a PBR, People Biodiversity Register, under the Biological Diversity Act, has 2 specific columns in every of that format. One is called associated TK, another is called TK use. So in any of those forms under the PBR, People Biodiversity Register, these 2 columns are mandatory. So if you document it there, yes, defensive protection can be taken up. And of course, the only other safeguard is an examiner listing oral knowledge under 3P, or that something is traditional knowledge as such, and preventing a patent. But as yet, we don't have anything with respect to copyright. I mean, unless the copyright registry, like the trademark registry, opens up, like the trademark registry has said that applicants can come and submit well-known trademarks, right? So something like that, if it can happen at the copyright registry, where traditional, TCs, traditional cultural expressions can be recorded in India, nothing like it. Nothing like it. But at this point of time, All I can tell you is that you create a database. Okay. I mean, this is indirect protection. So let us say you have a series of, traditional knowledge related information. You create a database, you document it under that, and take a database protection. That is, kind of indirect way of thing. I hope I've been able to answer your question. Yeah. So another one that is the local community free from difficulties in terms of procedural and technical compliance, especially the cost? Yes, it's a very valid question that you have raised. Local communities are not free from these difficulties. I can tell you, during the pandemic time, there were a series of, small medium enterprises. They are quite burdened, even if it means a few thousands. It's not easy for them to, uh, typically. If at all they have filed it, no, they don't want to pay early publication fee. We tell them that, look, if you pay early publication fee, your provisional rights are at least taken care of, and it obviously opens up the route for request for examination, because unless publication is done, request for exam. But sometimes it's really hard to uh, convince them. These difficulties we have faced. Maybe I don't know. Possibly either that they have a business mindset, but it is more product oriented. Not they don't see, because they don't see that IP is being bought. You get the point, right? See, if I go to a market, I purchase something, I'm physically seeing a product. But when they're investing in IP for a filing, for an early publication, or even an expedited examination, or even for a drafting of it, they start looking at it as a more input intensive process than outcome oriented. So they feel that, okay, I've already shelled out a lakh, madam, but nothing has come out of it. This is a challenge, because yes, we have to be procedurally compliant. This part is there. Technical compliance point of view, there is difficulty. You have raised a very interesting question. Um, uh, I can give you an example of GI, since you said local community based. What happens, like for instance, I won't mention the sweet preparation, but this one of the GIs in registered GI in Bengal, belongs to Bardhaman district. When we go there for a post GI work, no, they find it very difficult to have the technical compliance. For instance, the chana which is used, no, to make the sweet preparation comes from different households and from several people. Now they internally maintain quality control. Okay. Now they say that in future, when some of these are going to realize export market, how do we really make sure that it is scaled up to that? Which means we need a lot of technology support. Okay, that is one thing. Second thing is we need to really start looking at grading every process. Their technical compliance is a big problem, because I had very interestingly one of these proprietors asking, can we create a sensor, and if that sensor can detect this bundi they make, right, this laddu, and they have heaps of it, which they put, and they know that this is the amount that needs to be made, so they are always prepared. But sometimes they also face vagaries of the market, right? So the entire lot gets wasted. So they said, can we at least be able to use a sensor? So technology, uh, uh, to know how much of that material is already degraded, because they are also very quality conscious. So here is where they have difficulties, when it comes to the product point of view. I don't know if this is exactly what you were looking at. The cost part of it I already explained to you, but the technical compliance is also a huge issue. For example, sugar, date palm, they have huge issues, because the availability of date palm is coming down, because somehow those trees are not being fostered. Development is coming in way of cutting off those trees. They've been cut off, and resource is becoming much lesser. So they now want people to come forward and conserve, and then those kind of things are there. So it's more like that. But of course, your question is much wider when it comes to Cost, yes, they are affected by cost, I can tell you. I mean, very difficult to convince these startups. We had a workshop in one of these Purulia districts. They came up with some very, very interesting works, but none came forward for registration because they just find it that what is it like 3 4 days I have to spend on just the registration, that much of profit I'm losing. They say if you can take care of it, we'll give you everything, you only register, you finish it. And in any case, they can't believe that there is a cost associated with filing, and that's a continuing cost, just not the filing fee. So yes, this is a problem. Okay. Okay, if the work is see, there is the aspect of work during course of employment, work which is commissioned. So is it a work for hire? These are the notions we need to be clear, and that is decided by the policy. Your intellectual property policy will decide on who if you create the work on your own, obviously you're the copyright owner. But if you've been commissioned to work on something, then the question of the work is being owned by someone else. Well, this can also create another aspect of the thing where if I am having my insignia into the work, then how do I separate out the moral right part of it is a question. So in the course of employment, typically, if it is institutions, yes, we own the copyright because academic institutions enjoy that freedom. But yes, if you're working for a company, the ownership is with the company. So those works are actually with respect to them. Okay. If the patent can be granted if it is on what grounds can a patent be granted if the said invention is based on traditional knowledge? See, you have to derive it out of traditional knowledge. See, if you look at section 3P says traditional knowledge as such is not patentable, right? What does it mean? That if you're deriving out of traditional knowledge, it can be perfectly patentable. So how do we really take care of this in patent applications? We ask the client that have you used the extract as it is? You have just mixed something, extracted something, and that is there as it is, or are you using that as a ratio? So typically they would, and that ratio is not part of traditional knowledge. Then it is derived out of traditional. So I'm using the same hibiscus, I'm using the same neem oil, I'm using the same sandalwood. Fine, no problem. But traditional knowledge does not tell me that they are mixed in these proportions. So you have derived out of traditional knowledge, then it is perfectly patentable. This is how we do. Sometimes we see the drawing of Marcus claims with respect to traditional. Like for instance, I can say that, look, I have made this particular herbal syrup, and in this syrup, there is one component X. That X is a reference component. That X can be anything which is from the group consisting of, let us say, hibiscus oil, catharanthus oil, neem oil. So that means depending on my where I want to sell it, I can replace that X with either hibiscus or any of that. So though it is in the consisting format, it is still a broad claim because any one of those oils you can use. So typically in traditional knowledge related or cosmetic patents, you will find these Marcus claims where a little broad claim coverage is given. And their examiner typically points out TKDL because the moment they see Catharanthus roseus or they see Azadiracta, which is neem, it's okay, this is hitting with the traditional knowledge resource, TKDL resource, or any of the publications which are dealing with traditional knowledge. There, the only thing that you can argue is that I'm not using it as such, but I'm using it in a combination. Okay. And in any case, traditional knowledge does not give me the synergistic value. I am deriving a value totally different from what is disclosed in traditional knowledge. So this is how you would typically look at. Okay. Prior art search is not territorial. Prior art search, it says elsewhere also. You see the anticipation sections. It says prior art is by prior claiming in patent specification and elsewhere. So publication elsewhere, prior claiming in terms of patents elsewhere is also counted. So prior art search is not territorial. Prior search is done in India also, but even they look at even abstracts from other journals, abstracts from other patent offices as well. Okay, so that is how it is. And that is why it is called absolute novelty. It is novelty against the world. If you have come up with, see, please remember, copyright and patent are two different things. Novelty and originality are not the same. Independently, it can be original. I can create the same, write the same book without knowing that another author existed in another part of the world. Independent copyright can exist. Independent inventions do not exist. Do not exist. So that is the thing which you should be clear about. So if I've come up with an invention, none else in the world should. That is what is novelty. It's absolute novelty. That is the strictest form, in fact. What is the relationship between traditional knowledge and job? Okay, yeah. This is a good question. Yeah, many of the GIs actually have inherent traditional knowledge. For example, Pattachitra art, you see, Madhubani art, they are all associated with traditional knowledge. See, we worked with Pattachitra art of West Bengal. There is oral tradition also involved, with respect to that. They sing while they are actually doing the art. So this is something which is very, inherent with respect to many of the GI in the country. So there are many of them are traditional practices. So the relationship is quite strong in that, in fact. Okay, maybe I'll quickly move on. Yeah. TKDL is a bold step. Yes, that's correct. But in practice, many malpractices are being made. How far legislation? Yeah, so there you see, as the TK, we have not passed the TK rules as yet. But if that is passed into law, then we are going to have a law for TK. And in the TK law, there is something called a TK. It is TKR, TK register. If you see the rules, under that particular TK register, how they are planning to create TK register for the country, the TK register will have all the people biodiversity registers information, because I told you those two columns are there, associated knowledge and TK use. This is one thing. Second thing, TKDL is going to be inherently the part of TKR. This is one other thing. Then all those databases which have cataloged traditional knowledge, like for instance, Eastern Guard database, Western Guard database of traditional knowledge, all those will be integrated into one TKR of the country. Now, if you look at those, there also they've spelled out how the TKR will be accessed. So there is one part of TKR which is completely private and community specific, which will never be accessed cannot be accessed by anyone except community. This is the private or the secret TK. Then there is public TK, which is the documented TK. Then there's public restricted. So there are several categories that they've listed even under the TKR. So, but of course, we need to see, when that will come into practice. Yeah, codified TK has been explored. Yeah, the amendments to the Biological Diversity Act are going to open up a different paradigm, because the linkage between the community, the grassroots, the bottom-up approach of the Biological Diversity Act, possibly we are going to see loosening up of that. So access may become more easy now. But then, well, access may become more easy, but the question is India going to blow the benefit sharing part hard? That yes, we give you access, but what about benefit sharing? This is one thing which is a issue. Second thing is, it is at this stage also we need to be very careful as a country, because traditional knowledge also has a context of the moral rights paradigm. How much of that will be really safeguarded? That is also a question to really look at. So the concerns of, well, in India, we don't use the word indigenous people, we use the word local communities. Yeah, the concerns of how much the local communities are going to be taken into account is a big question. Do we, therefore, like see, many countries also list the type of communities. Do we need a listing of that? That is one thing. Second thing is, many countries also have community-specific legislation recognized under national legislation. So we need to see what will be the mode in which we really take this into, otherwise local communities are going to suffer. That if that flexibility, too much of flexibility is allowed, and yes, there will be malpractice. People will usurp a lot of TCs, and there ought to be a lot of violations. Though there are so many TK guidelines announced under the CBD, but many of them are only voluntary and non-binding. So it's yeah, that's an important question you have raised.